Item 38, 251, P. Srinivasarao garu.
Your last occasion, how the reservations system, particularly the horizontal reservation, how it evolved. We were considering the judgment rendered by Honorable Supreme Court. At least 3 judgments were based for issuance of new GO. For a moment, Lordship may kindly see state and subordinate service rules, how it existed before and what happened later. GO 77 is brought in, but before GO 77, what was the position has to be considered. Notification is post the amendment. Notification is post the amendment, but our grievance is that they have applied the old one. Instead of applying the GO 77, they followed the old system. That's how it becomes necessary. The Rule 22 of state and subordinate service rules.
Yes.
Reservations may be made for appointment in favor of scheduled caste, scheduled tribes, backward classes, women, physically handicapped, meritorious sports persons, ex-servicemen, and such other categories as may be prescribed by the government from time to time to the extent and in the manner hereinafter in these rules, or as the case may be in the special rules. The principle of reservation as hereinafter provided shall apply to all appointments to a service, class, or category by direct recruitment, except where the government by a general or special order made in this behalf exempts such service, class, or category. Otherwise, then by direct recruitment in principle of reservation in the matter of promotion, appointment, so and so. Of course, as far as the promotion is concerned, it has come into existence much later in 2003. The special representation, for the social services, the social categories, scheduled caste, scheduled tribes, was there from the beginning. Then for backward classes, it was introduced. Like that, it is slightly getting expanded by inclusion of other categories of people also. Then Lordship may kindly see 2. The unit of appointment for the purpose of direct recruitment shall be 100 vacancies, of which 15 shall be reserved for scheduled caste, 6 shall be reserved for scheduled tribes, 29 shall be reserved for backward classes, and the remaining 50 appointments shall be made on the basis of open competition and subject to Rule 22A of these rules. So therefore, on broader side, in every 100 vacancies, these are the reservations that are provided. 15 are provided for scheduled caste, 6 are provided for scheduled tribes, and 29 for backward classes out of every 100. And the remaining 50 appointments shall be made on the basis of open competition Subject to Rule 22A of these rules, the unit of appointment for the purpose of reservation in the matter of promotion and appointment by transfer involving promotion shall be 100 vacancies. That's about either promotion or appointment by transfer. From one cadre to the other cadre, if it is by appointment by transfer. That may not apply as far as the present case is concerned, because we are not on promotions. Then Lordship may kindly come to a cycle E is provided. Lordship may kindly come to E 22E. 22 2 A, B, C, D clauses are given. How it should be made. The roster points. I read. All these would apply insofar as the promotions are concerned. 2A is for direct recruitment. 2A1 is with regard to promotion. And then capital A, capital B, they are in respect of how to the preparing the panels. For a moment, Lordship may kindly come to see. Filling up the roster points shall continue till the required percentage of scheduled caste and scheduled tribes candidates is obtained. Once the required percentage is obtained by taking into account the scheduled caste and scheduled tribes and physically handicapped persons, candidates who are found in the list of candidates with a promotion on account of their seniority in the feeder category, and those who are moved up to fill up the required roster point, further adjustment of scheduled caste and scheduled tribe employees against roster point has to be stopped. Unutilized roster points after the required scheduled caste, scheduled tribes, and a physically handicapped person's percentage is met shall lapse if number of scheduled caste and scheduled tribes and physically handicapped employees are not available in the feeder category to obtain the required representation in the promotion category. The vacancies earmarked for scheduled caste, scheduled tribe employees according to the roster points will be carried forward. All these about the promotions, how it should be made. Is what indicated here. Lordship may kindly come to E. Appointments under this rule shall be made in the order of rotation specified below in a unit of 100 vacancies. Here, for the women, in the roster, the points are indicated. The first vacancy goes to open competition woman, second goes to scheduled caste woman, then fourth vacancy goes to backward classes A group women. Like that, sixth goes to physically challenged persons. The entire the roster is there. Lordship may kindly come to 100 100 the 100th vacancy is meant for open competition. And then Lordship may kindly come to 22A, capital E. The other provisions of the Rule 22, if required number of candidates are not there, what should be done? Limited recruitment thereafter. Limited recruitment can be made. What is the time limit? All that procedure is there. When it should be made, if the candidates are not available. That may not be necessary for this case. Lordship may kindly come to Rule 22, capital A. Woman reservation in appointments. Notwithstanding anything contained in these rules or special rules or ad hoc rules, in the matter of direct recruitment to posts for which women are better suited than men, preference shall be given to women, provided that such absolute preference to women shall not result in total exclusion of men in any category of post. In the matter of direct recruitment to posts for which women and men are equally suited, there shall be reservation to women horizontally to an extent of 33rd, 1/3 of the post in each category of open competition, backward classes, group A, B, C, D, E, scheduled caste, scheduled tribes, physically handicapped and ex-servicemen and a meritorious sports person quota. As far as the present case is concerned, this direct recruitment to the post for which women and men are equally suited. Present case this would apply. 22A, 2 would apply. Then 3. In the matter of direct recruitment to posts which are reserved exclusively for being filled by women, they shall be filled by women only. 1 and 3 does not apply. Only 2 would apply insofar as the notified vacancies are concerned. So the Lordship may kindly come to note 1 and 2. The principle of reservation for women candidates to the extent of 30% in the matter of direct recruitment shall be initially it was 30%. Then note 2. The principle of reservation for women candidates to the extent of 33rd, 1/3 in the matter of direct recruitment shall be with effect from 28/5/1996. So therefore, this is in existence. As far as this horizontal reservation is concerned, this is in existence from 1996 and 97 onwards. The cycle is given under the old rules. And which vacancy is reserved for women of which category is also indicated in this cycle of 100 posts. Now, Lakshmi, with this background, Lakshmi may kindly come to the GO along with the counter the government supplied 2 volumes. We are relying upon the government's but for convenience we are following this.
Yes.
Last occasion I was reading at page 75. Clause 12. In the GO 16th read above, accordingly, orders have been issued amending Rule 22 of the AP State and Subordinate Service Rule, substituting Sub-Rule 2 of Rule 22A, providing reservation to women horizontally to an extent of 33rd, 1/3 of the posts in each category of open competition, so and so, so and so. Is what I was reading on the last occasion. Now, Lordship may kindly come to the notification at page 78.
Yes.
Just a paragraph above the notification. Amendment to the AP State and Subordinate Service Rules. Government, after careful examination of the matter, keeping in view of the above judgments of the Honorable Supreme Court, guidelines of the Government of India, and existing orders of the state government, have accepted the report of Committee of Officials for implementation of horizontal reservations to the categories of women, persons with benchmark disabilities, ex-servicemen, meritorious sports persons, and also reservations to economically weaker sections and decided to issue necessary amendments to the AP State and Subordinate Service Rules. All departments, my lord, these lordships, all departments, state-owned corporations, societies, and also the universities shall follow and also conduct their recruitments strictly in accordance with the rules being amended below, and also amend their rules in conformity with the general rules being amended. Suppose, my lord, it's a university. They will have, my lord, separate standing orders. Even those standing orders, my lord, will have to be amended is the purpose, my lord, of this scheme. Accordingly, the following notification. Then, my lord, notification. In exercise of the powers conferred by the proviso to Article 309 of the Constitution and all other powers hereto, enabling the Governor of Andhra Pradesh hereby makes the following amendment to AP State and Subordinate Service Rules issued in GOMS. These are, my lord, old rules, my lord, 1996. Lordship may kindly come to the amendments, my lord, that are made. My lord, just now, my lord, I read, my lord, the Rule 22 of State and Subordinate Service. My lord, here, my lord, the amendments, my lord, Lordship may kindly see, my lord, the first amendment. In Rule 2, for Clause 22, the following shall be substituted, namely persons with benchmark disabilities. Then Lordship may kindly come to page 79, my lord, how the rules, my lord, were amended. My lord, there, my lord, for Clause E, my lord, I have pointed out, my lord, a cycle of 100 vacancies and how, my lord, reservations are provided, my lord, for women. Just now, my lord, I brought to the notice of Honorable Court. Now, my lord, page 79, Lordship may kindly see, my lord, here the change, my lord, the substantial change that is brought, my lord, through GOMS number 77 is this. For Clause E, the following shall be substituted. My lord, old one is completely removed. The following shall be substituted, namely, appointments under this rule shall be made in the order of rotation specified below in a unit of 100 vacancies for vertical reservations in direct recruitment. The first roster point would go to open competition, second goes to SC, third is open competition, fourth is BCA, fifth is open competition, sixth goes to open competition, seventh SC, ST. My lord, we can, my lord, the gaze, my lord, from this, that there is no, my lord, specific mention of any woman within the roster. My lord, earlier, my lord, the State and Subordinate Service Rules, my lord, earlier in the cycle itself, my lord, roster cycle of, my lord, 100 vacancies, my lord, the very first vacancy in the roster point was, my lord, given to open competition, woman. Second vacancy was given to SC, woman. Then fourth vacancy was given to BCA, woman. My lord, like that, my lord, the women, my lord, were given specific points within the, my lord, cycle. So, my lord, earlier, my lord, if a vacancy has to be filled up, it had to be filled up only with that candidate. My lord, if a scheduled caste person, my lord, within the, my lord, category, scheduled caste category, my lord, let us suppose, my lord, a male candidate is available with a higher, my lord, merit and a higher marks, higher rank. But, my lord, because that particular vacancy in the roster point has to be filled up with a woman should be given preference to him. She should be appointed.
But this is you are reading the amendments.
No, prior to amendment.
Page 79.
Now, after amendment.
No, page 79 is
Yes.
the amendment notification.
This is, my lord, this is after amendment. So, whatever, my lord, within the cycle, whatever woman, my lord, a post was reserved for them is removed, my lord, now. That's, my lord, my respectful submission. My endeavor is to.
You are questioning this.
Yes, this is not followed, my lord. Is our.
Page 79 is not followed.
Page 79, my lord, instead of following this system, they are still following the old roster, old cycle.
Where is the notification?
Yes, my lord, notification, my lord. page 13, my lord, it starts.
Where is the cycle which they have mentioned in the notification?
Yes, I'll. My lord, in order to, my lord, of course, my lord, this notification, my lord, is in the language that is given, my lord, in GOMS number 77. My lord, that would start, my lord, from page 24. Reservations, my lord, what they say. Is, my lord, they say, as if, my lord, they are following the new rules brought through amendment. Page 24, para 4.1, para 4 deals with the reservation. They speak that, my lord, they are following this, my lord, amended GO. There will be vertical reservation in direct recruitment in respect of scheduled tribe, scheduled caste,
Understand?
as per rule 22, 22A, 22B of state and subordinate service rules.
How do you
As
say?
amended, yes,
How do you say that they are following the old rules?
yes. My lord, the lordship may kindly come to, my lord, page. Page 35, lordship may kindly come. My lord, lordship may kindly see, my lord. My lord, page 35 for the executive post, my lord. My lord, post code number 1, municipal commissioner, grade 2 in municipal administration department. You know, it's a multi-zonal post. And then, my lord, they say, my lord, they are, my lord, fresh vacancies. My lord, OC, my lord, 1 OC. My lord, then they said, my lord, locals, total number of vacancies is 3. Similarly, my lord, for STs, my lord, they have placed it, my lord, under local category, my lord, 1 vacancy. Totally, my lord, 4 vacancies are there. Here, lordship may kindly see. Among the 4 vacancies, the following vacancies are reserved horizontally. The physically, my lord, challenged group, OH01, within the above community. Then, my lord, woman, OC1, ST1. My lord, this, my lord, showing, my lord, for the woman is, my lord, contrary to GO 77. My lord, they cannot show, my lord, woman here. My lord, what, my lord, the GO 77 contemplates is, my lord, a total, my lord, merit list, my lord, should be prepared, my lord, first. And in the merit list, my lord, the first 50 vacancies, my lord, should be selected as per the merit. And then, my lord, within that merit, if already, my lord, adequate number of women are recruited, my lord, then there is no necessity, my lord, for providing further reservation. If they are not provided, then, my lord, after, my lord, the touching, my lord, 50, then, my lord, in the rest of the 50, my lord, the reservation has to be provided. That's what, my lord, the Supreme Court said. But here, my lord, in the annexure, they mentioned that, my lord, if 4 vacancies are there, my lord, in the 4 vacancies, 1 is reserved for OC, 1 is reserved for ST. This kind of, my lord, a reservation is, my lord, on the base of, my lord, old cycle. It cannot be, my lord, under the new GO. Similarly, my lord, for the, my lord, lordship may kindly see, my lord, sub-register, my lord, just bottom, my lord, post code number 02, sub-register. Here, my lord, the bottom, my lord, zone 2, Lordship may kindly see.
I've seen women.
Same.
51.
Woman, OC1, BCD, O. My
Okay.
lord, then, my lord, zone 4 also, woman, OC2, BCD, 1, ST, so and so. My lord, like that, my lord,
Anitlono, చూసాను.
all my lord codes, my lord, post code number 3, deputy tahsildars, my lord, assistant labor officers, my lord, everywhere, my lord, woman reservation is, my lord, separate. Woman reservation and a physically challenged, my lord, persons also reservation. My lord, they are all, my lord, special reservations. My lord, they are to be provided under horizontal reservations. My lord, initially itself, my lord, marking these vacancies, my lord, for them, my lord, is bad.
Followed.
My lord, it would start, my lord. This page 35, my lord, annexure 1 would start. My lord, with reference to, my lord, all the posts, my lord, it would come up to, my lord, page 54, my lord. The last one is, my lord, post code number 59.
Right.
My lord, junior assistant in engineering chief.
చూసానండి.
And one vacancy, that vacancy is reserved for women. ST woman. Well, that's how, my lord, it is, my lord, bad. My lord, is my respectful submission. Then, my lord, Lordship may kindly come to the, my lord, before, my lord, issuance of notification, my lord, the normal procedure is, my lord, the concerned, my lord, departments, my lord, now that, my lord, 59 departments, my lord, we are able to notice. My lord, these departments furnish, my lord, information to the Public Service Commission through government about the existence of, my lord, vacancies, availability of, my lord, vacancies. What are the vacancies that have to be filled up? How many vacancies, my lord, are created? My lord, what is the sanctioned strength? Suppose, my lord, sanctioned strength is about, my lord, 30. And in the 30 sanctioned strength, how many vacancies are there? How many vacancies have to be filled up? Then, my lord, the another question would be, my lord, within, my lord, the vacancies, my lord, that are available, or, my lord, the posts in which already, my lord, people are working. My lord, the next question that would arise is whether these, my lord, the special categories, my lord, of persons are already adequately my lord, appointed or not. My lord, already, my lord, some people are working. Whether, my lord, adequate selection was made or not, whether adequate representation of the reserved classes is there or not, is the thing has to be considered. My lord, therefore, my lord, in the information that has to be furnished by each department, they have to specifically address to this system and inform, my lord, the Public Service Commission, saying that scheduled castes, they are not adequately represented. If they are not adequately represented, what are the number of vacancies that are not adequately represented? Similarly, my lord, for women, if, my lord, whether women are adequately represented or not, what is the deficiency, my lord, is the information that they have to furnish. And, my lord, basing on that, my lord, as per the, my lord, new GO, my lord, whether adequacy, my lord, has to be kept in view always, my lord, while issuance of notification by the Public Service Commission. That is what, my lord, the Honorable Supreme Court said. Now, with this background, my lord, Lordship may kindly come to, my lord, page, my lord, 223. My lord, a checklist, my lord, was provided. Lord, for instance, Lordship may kindly come to Lord, page 2223. It is Lord, postcode Lord, number 6. Lord, here, Lord, for instance, Lordship may kindly see. Lord, the designation of the post at page 223, Extension Officer, Panchayat Raj and Rural Development. Service in which it is included is Panchayat Raj service. And then, Lord, number of vacancies intended by the recruitment agency, you to carry forward vacancies from notification number 25 of 2018. In 2018, a notification was given for recruitment. Then these two vacancies could not be filled up. So therefore, those vacancies are lying from 2018 onwards. They have to be filled up. Is the information that is furnished here. C should make kindly similar to C. Whether roster points tallied with reference to previous recruitment. Yes. Whether any non-joining vacancies of the last recruitment indicate number and a roster point with a cycle. Yes, 2 carried vacancies from notification of 2018, 11 OC general in zone 1, 17 OC women in Nellore NL in zone 4. That means at the 11th in the roster, at the 11th roster point, 1 vacancy arose in 2018. And at the 17th roster point, 1 vacancy arose. So therefore, they are taking the old cycle. And in the old cycle, 2 vacancies which could not be filled up, they say, they are carried forward here. Once again, they want to provide, the reservation, for them, through this notice. That is, the purpose. At page 229. One is for carrying forward vacancy, and the second is for direct recruitment of current vacancies. 229 AP Public Service Commission requisition form for direct recruitment of current vacancies. This is details of the sanction post, designation of appointing authority, all that Lordship may just kindly just have a glance, and then Lordship may kindly come to page 231. Middle small Roman 4, details of rule of reservation to be followed for direct recruitment. Sanctioned cadre strength of the post, zone 1, 110, zone 2, 140, zone 3, 140, zone 4 like that. Then reservation for a local area, 70%. number of post vacancies to be filled up, number of vacancies reserved for to be filled up by local candidates in each local area as per the percentage fixed in SPF rules. Whether all vacancies reserved to be filled up by local candidates at the previous recruitments were filled. If not, the number of vacancies carried forward to the present recruitment. Then, my lord, where vertical reservations, my lord, is 3. Thus, the rule of reservations, AP State and Subordinate Service Rules, Rule 22, 22A, 22B, read with DOMS number 77, for appointments apply. If so, please specify the number of candidates to be selected under each classification for each local cadre, including the number of vacancies earmarked for open to all candidates. Then, my lord, the details of carried forward vacancies, state and district. My lord, here Lordship may kindly see, my lord. But as far as, my lord, the Roman 3 is concerned, zonal cadre, zone 2, category OC, vacancy 1, cycle, my lord, is 2nd. They want to follow, my lord, the same cycle. My lord, with the issuance of, my lord, GO 77, whatever cycle they were following hitherto should be stopped. A fresh cycle, my lord, would start from, my lord, vacancy number 1. My lord, but, my lord, they are following, my lord, the old cycle. And they say, my lord, it starts, my lord, with this indication, Lordship may kindly see. My lord, at page 232, category, my lord, the zonal cadre, zone 2, category, OC, roster point 67. My lord, under the same, my lord, old cycle, my lord, them similarly, my lord, Lordship may kindly come to zonal cadre, zone 4. They say, my lord, roster points 39 and, my lord, 29 and 35. My lord, these are what, my lord, indicated. Then, my lord, details of current vacancies, Lordship may kindly see. Last roster point to be filled up. My lord, in zone 1, they say, my lord, 29. And zone 2, they say 71. Zone 3, 24. Zone 4, 41.
Okay, you're not into the numbers. You mean to say that they should have followed, prepared a list on the basis of fresh roster?
For fresh recruitment, they have shown old roster, old cycle.
You mean to say they have to prepare a roster as per the new rule?
They should have prepared.
And then issue a notification.
Yes. They should go, my lord, with the new, my lord, cycle that is given under GO 77. My lord, GO 77, my lord, they have to, my lord, as per, my lord, this cycle, they have to, my lord, the fill up, my lord, all the, my lord, the reserved category, my lord, candidates with the reserved category. That, my lord, they are not doing.
Right. That's all is the case.
Lord, Lordship may for a moment, my lord, Lordship may kindly come to, my lord, second volume, my lord. Okay. 768, my lord.
What do they say in the counter?
My lord, in the counter, they say, no, we are following GO 76. My lord, all these, my lord, they don't, my lord, specifically say, my lord, why the old cycle should be followed, why they are not following the new. My lord, merely they assert that, no, we are following the new only. Lord, Lordship may kindly come to, my lord, page 768. Andhra Pradesh Public Service Commission requisition form for direct recruitment. Separate form should be used for each category of post, and incomplete forms will not be accepted. My lord, these are the particulars, my lord, that have to be furnished to the APPS. My lord, they prepared, my lord, format, my lord, for this purpose. Details of post for direct recruitment, AP Ministerial Service Rule, Junior Assistant, my lord, is the category. Now, Lordship may kindly come to, my lord, page 780. My lord, before going to that, my lord, page 772, Lordship may kindly come to. My lord, they themselves, my lord, in the format, my lord, they solicit, my lord, this information. Details of current vacancies, my lord, at page 772. Last roster point filled. Fresh roster point to be filled. Number of vacancies proposed to be notified. End roster point to fill. My lord, this is the information they are asking. And then, my lord, the state cadre, Lordship may kindly see, my lord, for STs, one vacancy is there. And it is the, my lord, the first cycle according to them, roster point number 8. My lord, from roster point number 8, it has to start, my lord, according to them. My lord, 1 to 7, they are filled up, old cycle. And, my lord, now from 8 onwards, it should be started, is there, my lord, intention. My lord, like that, my lord. At page 780 minutes.
Yes.
Column number 2 minutes, specifically they are asking minute for this information. Whether the exercise of adequacy of women, PBD, minute, physically challenged, minute, meritorious sports persons, ex-servicemen vacancies is made in terms of GOMS number 77 dated so and so. Answer is no. That exercise has to be made by the departments. And they say no. What happened, for these 29 departments, similar fashion, the requisition forms in the prescribed format, the information, is supplied by the departments. And in the departments, supplied, information, when we, take all the information and we prepared, in notes for ourselves, it is, out of, the total, 59 departments, 28 departments said they have followed the adequacy, they have considered the aspect of adequacy, and then they filled up the columns. 2 departments said we did not conduct any such adequacy at all. And 29 departments remained silent, kept it blank. Out of 59, only 28 departments said that they have verified the adequacy of the horizontal reservations. Whether women are sufficient number of women are already recruited or already available or not. If not, how many vacancies have to be filled up now? Is the adequacy test. That even the departments doesn't furnish information. Yet with the partial information that is given to Public Service Commission proceeds and issues the notification. Our first point is that the new cycle is not started. As per new cycle, the reservation has to be made. Second point is that the adequacy is not mentioned by substantial number of departments. Yet the notification is given. Therefore, the notification is bad. That's basically that's our argument.
These are aspects which can be corrected at best. But these are aspects which can be corrected also.
No, which can be corrected, but my lord, the notification, my lord, has to be, my lord, if they have proceed with the recruitment, my lord, in this fashion.
Two parts. One is exam. Second part is recruitment. Second part is appointment. These are issues with regard to appointment.
Yes. My lord, these are, my lord, issues.
Bifurcate. We can bifurcate.
Yes. My lord, at the time of, my lord, recruitment, my lord, because, my lord, certain vacancies, my lord, as per the notification. In the annexures, my lord, just now I have pointed. My lord, where, my lord, one vacancy is given. And they have notified, my lord, they have shown in the annexures that, my lord, that vacancy is reserved, my lord, for ST women. My lord, a candidate who is, my lord, aspiring for a post, my lord, in that particular department will not apply, a male candidate, because it is already reserved. Notification shows that it is reserved. So therefore, my lord, he will be deprived of, my lord, an opportunity to participate. They should not have shown that so-and-so vacancy is reserved for so-and-so woman exclusively. One vacancy that is reserved. Rest of the candidates, my lord, will not be in a position to participate. But that's how, my lord, their chances, my lord, are reduced. My lord, they should have indicated, my lord, new cycle would be followed. Then, my lord, everybody, my lord, would have, because new cycle, my lord, goes on merit only. My lord, on merit, they have to prepare the list. And within the merit of, my lord, vertical reservation, horizontal reservation has to be fixed. So therefore, my lord, everybody expects, my lord, on merit, they will get, my lord, a fair chance. But now that, my lord, these, my lord, particular posts are, my lord, shown as reserved, my lord, for reserved classes, maybe women or, my lord, AC. My lord, the chances of, my lord, participation, my lord, gets reduced. My lord, is the third point. Third on, my lord, the kindly have a look at, my lord, the landmark judgment, my lord. Indira Sani and others, my lord, 1990 constitutional bench judgment. Only relevant, my lord, paragraphs, my lord, I read. The bench was comprising, constitutional bench, Lordship knows, my lord, was comprising of, my lord, 9 honorable judges. My lord, 6 honorable judges, my lord, have taken, my lord, the majority view. And the 3 judges, my lord, have taken, my lord, the minority view. Lordship may kindly come to, my lord, page 222, my lord.
222 of?
220, page 222, my lord. Page 220. Just, my lord, to know, my lord, which judge has written what. My lord, an introduction is given because, my lord, it's a big judgment. Parawise sequence of 6 judgments, my lord, even though, my lord, majority judgment, my lord, he is written, my lord, by Justice, my lord, Jeevan Reddy. My lord, 2 other judges, my lord, have given separate view, my lord, views, but concurring with the view expressed by, my lord, Justice Jeevan Reddy for, my lord, more elucidation. And the 3 judges, my lord, have taken, my lord, minority view. My lord, para 2, my lord, the parawise sequence of 6 judgments is as follows. Para numbering as given in some of the judgments and the references therein having been renumbered accordingly. Justice Panjan, paras 1 to 224, domain justice, paras 245 and 325. My lord, they are, my lord, order on behalf of the minority judges. Justice Kuldeep Singh, Justice Sawant, Justice Sahai wrote separate judgments concurring with, my lord, Justice Jeevan Reddy. Justice Jeevan Reddy, my lord, on behalf of, my lord, his lordship as well as, my lord, Chief Justice, my lord, Khania and, my lord, Justice Venkatachalaya Ahmadiyya and himself, my lord, the judgment is wrote. My lord, this is how, my lord. Then, my lord, on the aspect of, my lord, adequacy, my lord, how, my lord, it was considered, my lord, Lordship, a separate question, my lord, was framed and questions are answered. My lord, Lordship may kindly come to, my lord, page 284. Left-hand side top, my lord, page number is part 2. Questions before the 9 judges bench. Question 3F. Adequacy of representation in the services under the state, my lord, is what, my lord, it starts. Then Lordship may kindly come to, my lord, only relevant portions, my lord, the majority. At page 577, paragraph 516. Page 577, right-hand side top, paragraph 516. Article marriage. Article 16(1). Below the Constitution is a right created constitutionally in favor of all citizens, and anyone is entitled to approach the courts against violation of his right by the state and assail state's latitude in remedial measures or affirmative action to improve conditions of weaker sections or improve lot of backward class if they are not so tailored as not to transgress the constitutional permissible limits. Any state action, whether affirmative or benign, protective or competing, is constitutionally restricted first by operation of Article 16(4) and then by interplay of Article 16(4) and 16(1). State has been empowered to invade the constitutional guarantee of all citizens under Article 16(1) in favor of any backward class of citizens only if, in the opinion of government, it is inadequately represented. My lord, the earlier, my lord, prior to, my lord, Indira Sani case, my lord, there was, my lord, a notion that, my lord, proportional reservation should be made. Suppose, my lord, there is a population of, my lord, 10% of, my lord, scheduled caste in a state. 10% reservation should be, my lord, in the total, my lord, population. If 10% of, my lord, people are there, then 10%, my lord, should be provided, was the earlier, my lord, notion. Now with the Indira Sani's case, my lord, what is, my lord, held by the Honorable Supreme Court is that adequacy of representation. My lord, that, my lord, proportional representation is removed. Now adequacy of representation is brought because, my lord, within, my lord, 100, my lord, the maximum reservations, my lord, should not exceed 50%. 50% is the maximum cap, my lord, that is put by the Honorable Supreme Court. So within this 50, my lord, they should be, my lord, adequately reserved. That's how, my lord, adequacy, my lord, has come. Only if, in the opinion of the government, it is inadequately represented. Objective being to remove disparity and enable the unfortunate ones in the society to share the services to secure equality in opportunity and status. Any state action must be founded on firm evidence of clear and legitimate identification of such backward class and their inadequate representation. Absence of either renders the action suspect. Both must exist, in fact, to enable state to assume jurisdiction, to enable it to take remedial measures. Power to make reservations as contemplated by Article 16(4) can be exercised only to make the inadequate representations in the services adequate. Use of the expression in the opinion of the state may result in greater latitude to state in determination of either backwardness or inadequacy of representation, and the sufficiency of material or mere error may not vitiate, as state may be left in such field to experiment and learn by trial and error with little interference from the court. But if the principle of identification itself is invalid, or it is in violation of constitutionally permissible limits, or if instead of carefully identifying the characteristics which could clothe the state with remedial action, it engages in analysis which is illegal and invalid and is adopted not for remedial measure purposes, but due to extraneous considerations, then the court would be shirking in their constitutional obligation if they fail to apply the corrective. State's latitude is further narrowed when, on existence of two primary, basic or jurisdictional facts, it proceeds to make reservation, as the wisdom and the legality of it has to be weighed in the balance of equality, pledged and guaranteed to every citizen, and tested on the anvil of reasonableness, and smoke out any illegitimate use and restrict the state from crossing clear constitutional limits. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed. Government should control the governed. And in the next place, obliged to control itself. Judicial review has come to be one of the ways of obliging government to control itself. A reservation for a class which is not backward would be liable to be struck down. Similarly, if the class is found to be backward, but it is adequately represented, the power cannot be exercised. Therefore, the exercise of power must precede the determination of these aspects, each of which is mandated. So therefore, my lord, the governmental departments have to consider whether a particular class, my lord, is adequately provided or not, whether it is vertical reservation or, my lord, horizontal reservation. So unless, my lord, the adequacy test is, my lord, passed, my lord, they cannot make, my lord, the recruitment. My lord, Lordship, I can now, my lord, come to, my lord, page 605. Para 595, page 605. Reason for backwardness or inadequate representation in services of backward Hindus prior to 1950 were caste division, lack of education, poverty, feudalistic frame of society, and occupational helplessness. All these barriers are disappearing. Industrialization has taken over. Education, thou state effort, and due to awareness of its importance, both statistically and actually, has improved. Feudalism died in the 50s itself. Even the Mandal Commission accepts this reality. Any identification of backward class for purposes of reservation, therefore, has to be tested, keeping in view these factors, as the exercise of power is in present T. Importance of word is in Article 16(4) should not be lost. Backwardness and inadequacy should exist on the date the reservation is made. Reservation for a group which was educationally, economically, and socially backward before 1950 shall not be valid unless the group continued continues to be backward today. Today, the backwardness should be there. That is what, emphasis given by the Supreme Court. The group should not have suffered only, but it should be found to be suffering with such disabilities. If a class or a community ceases to be economically and socially backward, or even if it is so, but is adequately represented, then no reservation can be made, as it no more continues to be backward, even though it may not be adequately represented in service, or it may be backward, but adequately represented. That's how, the adequacy, is what, is proposed to be considered. Then, para 599, at page 607, next page. Thus, para 599. Thus, backwardness and inadequacy of representation in service must exist on the date the reservation is being made. Any past injustice which entitles a group for protective discrimination must, on principle of compensation or social justice, be continuing on the date when the reservation is being made. Is what the Honorable Supreme Court said. Then Lordship may kindly come to page 614, para 609. Six hundred and 14, para 60. Identification alone does not entitle a group or class to be entitled for protective benefits. Such a group or collectivity should be inadequately represented. Use of such words as adequate or inadequate are no doubt wide and vague, and their meaning has to be gathered largely on the point of view from which the facts may be proved or reconsidered. But from the purpose and objective of Article 16(4), a collectivity or group which is found to be backward cannot qualify for being included if it is adequately represented. Word any has great significance. In wider sense, it extends to and includes all group or collectivity which is as much any backward class as any singularity. In the larger sense, comprising of entire plurality, it continues and may continue, but in the limited sense, the group may keep on getting in and out, depending on continuance of those conditions which are entitled to be determined as backward. A government of a state or the central government may, on evaluation after 5 or 10 years, direct a group or collectivity to be excluded from the list of backward classes if it finds it adequately represented. What is adequate representation is, of course, the primary concern of the government, but the exercise should be objective. For instance, in some states, it was found by commissions appointed by their governments that certain castes were adequately represented. Yet, because of extraneous reasons, the government had to bow and include them in the list of backward classes. Such inclusion is a fraud of constitutional power. Any citizen has a right to challenge, and the court has the obligation to strike it down by directing exclusion of such a group from the backward class. Inadequacy provides jurisdiction not only for exercise of power, but its continuance as well. If that itself ceases to exist, the power cannot be continued to be exercised. Where power is coupled with the duty, the condition precedent must exist for valid exercise of power. Mere identification of collectivity or group by a commission cannot clothe the government to exercise the power unless it further undertakes the exercise of determining if such a group or collectivity is adequately or inadequately represented. The exercise is mandatory, not in the larger sense, but not in the larger sense alone, but in the narrow sense as well. Both senses, in the larger sense as well as narrow sense. That exercise, adequacy has to be conducted and it is, my lord, mandatory. My lord, Lordship may now, my lord, come to, my lord, page 727, my lord, 798. Then, my lord, I will read only two paragraphs. My lord, page 727.
727.
727. Para 798. Not only should a class be a backward class for meriting reservations, it should also be inadequately represented in the services under the state. The language of clause 4 makes it clear that the question whether a backward class of citizens is not adequately represented in the services under the state is a matter within the subjective satisfaction of the state. This is evident from the fact that the said recruitment is preceded by the words, in the opinion of the state. This opinion can be formed by the state on its own, that is, on the basis of material it has in its possession already, or it may gather such material through a commission or committee, person or authority. All that is required is there must be some material upon which the opinion is formed. Indeed, in this matter, the court should show due deference to the opinion of the state, which in the present context means the executive. The executive is supposed to know the existing conditions in the society, drawn as it is from among the representatives of the people in parliament and legislature. It does not, however, Milord, this is now, Milord, again a rider. It does not, however, mean that the opinion formed is beyond judicial scrutiny altogether. Milord, court, Milord, reserves, Milord, the judicial scrutiny power. The scope and reach of judicial scrutiny in matters within subjective satisfaction of the executive are well and extensively stated in barium chemicals, which need not be repeated here. Suffice it to mention that the said principles apply equally in the case of constitutional provision, like Article 14, which expressly places the particular fact inadequate representation within the subjective judgment of the state or executive. Milord, the conclusion, Milord, paragraph. Milord, after, Milord, considering all these, Milord, at paragraph 859, Milord, page 766. Milord, summarized. Everything is summarized. Para 859. Lordship may kindly see, Milord. 2C, Milord. Reservations can also be provided under clause 1 of Article 16. It is not confined to extending of preferences, concessions or exemptions alone. These reservations, if any made under clause 1, have to be so adjusted and implemented as not to exceed the level prescribed for backward class of citizens, as explained in this judgment. Then, Milord, Lordship may kindly come to, Milord, F. The, Milord, next page, Milord, 767, F. The adequacy of representation of a particular class in the services under the state is a matter within the subjective satisfaction of the appropriate government. The judicial scrutiny in that behalf is same as in other matters within the subjective satisfaction of an authority. Milord, the paragraphs are given. I read, Milord, those, Milord, are relevant paragraphs only. And then this is, Milord, on, Milord, Indira Sani's case. Milord, at the point of, Milord, that time, Milord, when Indira Sani, Milord, was referred, Milord, the provision of, Milord, reservations, Milord, for women, Milord, was not, Milord. It's only, Milord, the reservation that is provided to, Milord, backward classes was the issue. Milord, Mukesh Kumar and another, Milord, this is 2020. Milord, 3 Supreme Court cases, 1. Lordship may kindly come to, Milord, para 8. I read para 8, 12 and 13. In the meanwhile, respondents in restriction number so-and-so, that is the state of Uttarakhand, filed an application for review of judgment dated 1/4/2019. The High Court realized that it committed an apparent error in its judgment dated 1/4/2019, while deciding the writ petition by referring to the judgment of this court in Journal Singh. The High Court clarified that the state government is obligated to collect quantifiable data regarding inadequacy of representation of the scheduled caste and the scheduled tribes in state services before providing reservations in promotion. That was for promotion. The High Court clarified that it is not necessary for the state government to collect data regarding backwardness of scheduled castes and scheduled tribes in the light of direction of this court in journalism. The High Court also observed that the state is not obligated to provide reservation in promotions to members of scheduled caste and scheduled tribes, as Article 16(4)(a) of the Constitution is an enabling provision. However, reservation can be provided by the state government only after collecting data regarding inadequacy of representation of the scheduled castes and scheduled tribes in the state services. As such, the High Court directed the state government to collect quantifiable data regarding inadequacy of the representation of the scheduled castes and scheduled tribes in government services, which would enable the state government to take a considered decision on providing or not providing reservation. The state government was directed to take a decision whether to provide reservation or not only after considering the data relating to the adequacy or inadequacy of representation of scheduled castes and scheduled tribes in the services of the state within a period of 4 months from the date of receipt of the judgment. Then agreed by that, the matter was carried to Supreme Court. Then Supreme Court at para 12. Para 8 gives the facts. Para 12. Article 16(4) and 16(4)(a) do not confer fundamental right to claim reservations in promotion. Promotion, it's not a fundamental right. It is only an enabling provision to the state government. By relying upon earlier judgments of this court, it was held in Ajit Singh that Article 16(4) and 16(4)(a) are in the nature of enabling provisions vesting a discretion on the state government to consider providing reservations if the circumstances so warrant. It is settled law that the state government cannot be directed to provide reservations for appointments in public posts. Similarly, the state is not bound to make a reservation for scheduled castes and scheduled tribes in matters of promotions. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing inadequacy of representation of that class in public services. If the decision of the state government to provide reservations in promotion is challenged, the state concerned shall have to place before the court the requisite quantifiable data and satisfy the court that such reservations become necessary on account of inadequacy of representation of scheduled castes and scheduled tribes in a particular class or classes of posts without affecting the general efficiency of administration as mandated by Article 335 of the Constitution. Article 16(4) and 16(4)(a) empower the state to make reservation in matters of appointment and promotion, both in favor of SCs and STs, if in the opinion of the state they are not adequately represented in the services of the state. It is for the state government to decide whether reservations are required in the matter of appointment and promotions to public posts. The language in clauses 4(4)(a) of Article 16 is clear, according to which the inadequacy of representation is a matter within the subjective satisfaction of the state. The state can form its own opinion on the basis of the material it has in its possession already, or it may gather such material through a commission or committee person or authority. All that is required is that there must be some material on the basis of which the opinion is formed. The court should show due deference to the opinion of the state, which does not, however, mean that the opinion formed is beyond judicial scrutiny altogether. The scope and reach of judicial scrutiny in matters within the subjective satisfaction, same is extracted, as in Indira Sani's case, para 798. My lord, therefore, my lord, this exercise, then, my lord, Lordship may kindly come to, my lord, para 18 also, my lord, I read para 18 also. Fourth line, my lord, para 18. In view of the law laid down by this court, there is no doubt that the state government is not bound to make reservations. There is no fundamental right which inheres in an individual to claim reservation in promotions. No mandamus can be issued by the court directing the state government to provide reservations. It is abundantly clear from the judgments of this court in Indira Sani, Ajit Singh, Nagaraj, and Jarnail Singh that Article 16.4 and 16.4a are enabling provisions, and the collection of quantifiable data showing inadequacy of representation of SCs, STs in public service is a sine qua non, essential minute feature, is a sine qua non for providing reservations in promotion. The data to be collected by the state government is only to justify reservation to be made in the matter of appointment or promotion to public post according to Article 16.4 and 4A of the Constitution. As such, collection of data regarding inadequate representation of members of the SCs, STs as noted above is a prerequisite for providing reservations and is not required when the state government decided not to provide reservations. Not being bound to provide reservations in promotion, state is not required to justify its decision on the basis of quantifiable data showing that there is adequate representation of members of the SCs, STs in state services, even if the underrepresentation of SCs, STs in public services is brought to the notice of this court, no mandamus can be issued by this court to the state government to provide reservation in the light of the law laid down in C.A. Rajendra and Suresh. Therefore, the direction given by the High Court that the state government should first collect data regarding adequacy or inadequacy of representation of SCs, STs in government services on the basis of which the state government should take a decision whether or not to provide reservation in promotion is contrary to the law laid down by this court and is accordingly set. Yet another direction given by the High Court in its judgment, expecting that all future vacancies are to be filled up by promotion in the post of assistant engineer should only be from members of it. Ultimately, the Supreme Court was considering the aspect of promotions there. But in the appointments, the counter of the government public service. Should I finally come to the minute 3:33. I've already pointed out one such instance. But where they said 3:33 once again. Whether the exercise of adequacy of women, PBD, meritorious sports person, ex-service when vacancies is filled in terms of GOMS members. So, here also, this department also. Says, no, this is Director, State Audit, Mangalgiri. That department says, no.
Page number?
Page number 333. But here at page 334 also large mechanism. Lord, once again, Lord, they mention Lord, the roster points. Annexure lordship में kindly similar. Annexure roster points to be filled. Millard zone 1 roster point number 66 SC woman. They give Millard the roster point.
Page number
334 Millard. Zone 1 Millard. It's a tabular form. Millard, column number 2 is Millard roster points to be filled. Column number 1 is Millard zones and vacancy. Millard zone 1 Millard there is one vacancy. They say Millard roster point 66. Millard meant for SC woman. Then zone 2 they say Millard 67. It is Millard for OC they say. And Millard it has then Millard that is not Millard roster point is mentioned. Then Millard for women Millard third vacancy roster number 90. Out of 3 vacancies, one is reserved Millard for OC. Millard they show Millard as it is meant for OC. Then Millard one is 89 at roster point number 89. It is for BCD. At 90 Millard it is Millard for OC woman. Millard similarly Millard zone 4 also lordship में कहेंगे से. Millard they give Millard the roster points once again. Millard showing as if Millard these are the reserved pool. And Millard I have Millard prepared Millard a table. Millard we will pass on Millard this entire table. When Millard out of these 59 Millard departments, Millard which Millard remained silent and Millard which said Millard no. Millard for the Millard departments Millard which remained silent. Millard page 225 Millard I have pointed out. Just Millard page numbers Millard I will give. Millard, these are the tables, Millard. Of course, Millard, we will prepare Millard a comprehensive Millard table and give it. Millard, because Millard out of 59 Millard departments, Millard has already submitted by me. Millard, only 28 departments Millard have Millard followed this adequacy and they represented who are Millard adequately reserved and who are not Millard provided. Millard adequately Millard reservation is there. The rest of Millard 31 departments did not provide any information at all. In the absence of Millard such a Millard an exercise to be made Millard by those departments, Millard the recruitment notification should not have been given. Even now Millard after following Millard the adequacy, Millard after securing Millard the complete information, Millard the Public Service Commission Millard can proceed Millard with the can Millard afresh Millard issue Millard a notification is my Millard respective subject. And their counter Millard for a moment, Millard page 1 Millard it starts. Millard Lordship may kindly come to Millard. There are 7 Millard. It is submitted that each department submitted that each department in respect of whom the vacancies were requisitioned and the recruitment process is being undertaken by this respondent had furnished details of the post that fell vacant in each of their departments. They had also indicated in the said requisitions the category of post which thus fell vacant. This respondent did not provide any reservation by itself. Lord, what they are trying to say is the Public Service Commission doesn't provide any reservation. Whatever they provided, we incorporated in our notification. When they themselves say, 31 departments, did not do so. Notification, cannot, they depend upon, old roster. And they say, yes, what they furnished, we are recruiting, they cannot say. Then Lakshmi kindly come to, the page 7, just 4 lines above, para 10. As this recruitment, 5 lines, 6 lines, as the reservations were already provided in each of the departments in accordance with this cadre strength. As this recruitment is in respect of vacancies caused in each of the departments, that too in a particular reserved category, and as this respondent is undertaking the recruitment process as per the requisition, the petitioners cannot contend that there were any fresh reservations or that reservations are in violation of law declared by the Honorable Supreme. Lord, they merely say whatever they are requesting, we are doing. The statutory duty is on the Public Service Commission is to see that the reservations are made in accordance with the Constitution and in accordance with Rule 22 of State and Subordinate Services. They cannot merely say if the requisition department is committing some illegality, we will also commit the same illegality. It is not open for the Public Service Commission to say so. And then para 14. In response to para 8, it is submitted that petitioner cannot make any reliance on roster points formed by Government of India. Para 14. The state government issued GOMS number 77 dated 2/8/2023. The said GO provided the rules relating to recruitment, reservations to different categories, and the order of rotation in a unit of 100 posts in vertical reservations in direct recruitment. The recruitment process was undertaken as per this GO. At any rate, all this is irrelevant so far as this writ petition is concerned, because the present recruitment is not in respect of any fresh post to implement any rotation taking a unit of 100. According to them, new posts have to be created. The existing sanctioned strength has to be increased. And only then the new cycle would start. This is the meaning they are giving. They say, at any rate, all this is irrelevant so far as this writ petition is concerned, because the present recruitment is not in respect of any fresh post. These are the vacancies that are existing within the sanctioned strength of the departments. Even for them, the Honorable Supreme Court said reservations have to be provided, adequacy has to be seen. They cannot say only for fresh posts we will consider GO 77. For the existing vacancies, we will not follow these. Therefore, even the counter that's filed, is not properly giving a reply to our contention. Therefore, my respectful submission is that the notification itself is bad, and it has to be set aside. And a fresh process after completion of all this exercise has to be started.
Okay.
That's all.
But as far as me is concerned, to add, the reservation that is being applied, is not being on post based. Lordships have well aware of this RK overall. It has been categorically held that I'm adding what It's been categorically held that reservation should be post based, not vacancy based. What the respondents are doing is that wherever there are vacancies, they are taking that vacancies into consideration and they are playing roster, taking into account the point where it stopped in the previous site.
All right.
So they are not as being contended by my land senior counsel. They are not taking into account the total posts in the cadre. They are not calculating how many reserved candidates are there, whether they have reached the adequacy or not. In case what are the total number of posts, and where there is a requirement to apply this reservation, nothing. For suppose if from 1 to 100 posts are appointed, in that vacancies arises, they are starting from the point where it previously stopped. The reason the injustice that would be done is, for suppose a candidate belonging to a scheduled caste retire from service. If your lordships reads R.K. Sabharwal says, once you fix the point, it will be there. What you have to advertise is the vacancy. Clear? What you have to advertise is the vacancy. When the new post is there, then new cycle will start. Therefore, once if there is any vacancy, they can advertise the vacancy, no problem. But they can't apply this roster, which is amended from time to time. The last amendment is by virtue of this GOMS 77. They cannot implement the roster on vacancy base. Has to be post based. They have to calculate this adequacy. If there are required number of these the reserved candidates belonging to certain groups, they can't further apply the reservation. Likewise, horizontal reservation. As far as horizontal reservation is concerned, they have to check the adequacy at the time of appointment. And they cannot fix any points. Be it a physically handicapped candidate or a woman reservation candidate. Likewise, what they have done is.
Carry on.
For physically handicapped candidates, what they have done is the statute Persons with Disabilities Act describes only 1% reservation for physically challenged people who are with benchmark disabilities. For example, like persons with blindness, etc. They have given 4% reservation. Disability is different from benchmark disability. Therefore, they have done nothing. There no exercise is done. Simply, even where there are at serial number 35, Lordship sees the notification. Where there is a single post is there, they applied rule of reservation, which is to be uncalled for, which has categorically advised in the Supreme Court and a 5-judge judgment. When there is only one post, you cannot apply reservation. It's an open category.
It is not one post.
Yes, it is there.
I've seen.
Have a look at serial 35.
It is one vacant post. It is not one post.
Post code is 35.
Oh,
Senior Assistant Director of AP State Archives. Only one post. Okay, I'll argue on that also, not they reserved it for OC. One vacancy, lordships treat it as vacancy. They said it is for OC. Therefore, my lord, as contended by my grand senior friend, they have done no exercises while fixing the roster. And two, my lord, what I have challenged, my lord, if lordships have seen my reputation, please have a look at my reputation.
Go ahead, go ahead. I'm still in the first round. Chip. I'm just trying to hear everybody out. Then I'll come back.
In which the roster is fixed is also wrong in this UMS 77. Lordships have looked at the manner in which it is fixed.
In GO 77, amending the rule. Then you have to challenge the wires.
Rule is wrong. Prerogative of the state not fix percentage of reservation. I have no say on that. Neither the court will say something on that because it's a state prerogative. So what I said is you have fixed the roster point system. The manner in which you have fixed it is wrong. It is contrary to what it is said in RKS overall, plus the memorandum issued by the central government following RKS. I feel that is why I'm very cautious. What I said is full position I cannot challenge. It's up to the state. The manner in which they have fixed this table. Lordship sees the table. Please have a look at the table. The first point fixed is unreserved. Okay. Immediately thereafter, see.
That is also part of the rule.
Percentage.
Whatever it is, as it stands today, it's part of the rule.
In which it is fixed only even suppose if I say, see, you 16% is not correct for SCs, then your lordships are right. But I didn't say that. What I said is, for suppose SC, you have fixed the point at serial 2. Then please come to immediately thereafter they have fixed it at 7.
Still, it is part of statute. Still, it is part of the rule. It's part of 22.
Is the percentage at which the reservation is fixed. The top clause in that rule.
The roster is also a part of the rule. Point 100 point. No, 22E. 22E. It is part. This roster is part of the rule. That was there even earlier also. It's roster.
The lordships are right. It has to go before the first court. Full position, my lord. The manner in which, my lord, they fix the points, my lord, I have challenged.
Okay. Go ahead.
So what I said is, following RKS approval, the central government issued an office memorandum, the manner in which this point is fixed. unless you complete one complete oversteps, you cannot fix a point for this social reservation. That is why we wrote complete number of oversteps should be calculated like this. We wrote first post into percentage of reservation divided by, you know, whether it is, you know, a 100-point roster, it will be divided by 100. If it is a 200-point reservation, you know, roster, it will be divided by 200. So the one complete step will be achieved, then when, you know, the first 1 point is reached. For example, for schedule caste, the first point will be reached at serial 7. I have detailed a lot in my affidavit. Please have a look at page 16.
Here, go ahead with your preliminary argument. This won't end so soon.
So the first point for a schedule caste person will start at page 0.7. They have fixed it at page 0.2. Likewise, person belonging to backward classes 1, it is correctly fixed. For scheduled tribe, it should be at 8. Sorry, scheduled tribe, it should be at 17. First point. They have fixed it at serial 8. And economically weaker section is fixed at 10, which should be given to BCD2. And then again, which should go to a backward class was given to SC at serial 14. This method of calculation, which is adopted by central government, is given a go by. And they have not calculated. I don't know how on what basis they have calculated the and fixed these points. They should only explain. Though I have said that they are wrongly fixed, the counter there's no answer to that at all. And at the cost of recognition, post-based reservation also, they didn't dispute. The themselves in the counter, they say that they are given the reservation based on vacancies and not based on fair post. On that ground alone, the entire notification should go below. Likewise, the interlocking reservations, for females and handicapped people, no points can be allotted. They have to check the adequacy at the time of appointment. And as lordships are pointed, can it be corrected? But once a post is advertised saying it is reserved for a ABC person, naturally the person who is competent or more competent than the person who applied, and the person who is more competent thinking that the post is that particular category person has not applied, will definitely not lose a post. That is why this notification is wrong in all respects. If lordships take any judgment, Indira Sani or R.K. Sabharwal and subsequent judgment, wherever it is there, the Supreme Court has categorically held that once the post-based reservation is there, then comes the horizontal. In the absence of this, they have issued this notification. To my knowledge, as a matter of rush, without even calculating the adequacy in each social group plus special group. Nothing they have done, no work was done. And the notification, entire notification should be quashed. I have taken a specific stand in my affidavit that the reservation cannot be vacancy based. Can be only post based. I filed the judgment of R.K. Sabharwal in my petition. Lordship will find it at page 186 to 194. What is, my lord, undone by the previous, what is done in the previous notification, my lord, undone by virtue of 77 amendments. They are redoing, my lord, by fixing roster for all that.
All right.
The rest of the argument, my lord, I follow.
Adopt. You adopt.
I adopt.
Don't follow.
The learned senior counsel is that the entire notification is not based on, they have applied the reservation not based on vacancies and not post base.
All right.
And after state bifurcation, they have done nothing. Some posts, some posts have gone to Telangana, some posts have gone to Andhra Pradesh. They are not redone the adequacy, the calculation and all, which they admit in the counter-affidavit filed in previous writ petitions before the this honorable. And no, it is not disputed in the counter-affidavit in my case also that they have adopted vacancy base, which is illegal, should go their notification should go.
Right. Who else? Who else is here?
Wednesday.
Third senior counsel, Veera Reddy and M.R.K. Chakravarti. I'm not shutting you out. Posting it on Wednesday. Further arguments post on Wednesday. Yes. Sorry, Tuesday. I thought it's a bad day for Tuesday. Tuesday.
In
Part third still remains part third until it is completed. That's it, madam. Yes, Amarinder. Next week we'll see. Monday I can't say. Tuesday and Tuesday together. Monday. Item 150.